morning friends to the course Current Regulatory Requirement for Conducting Clinical Trials in India for Investigational New Drug and the New Drug version 2. Up to this we have seen 6 lecture regarding this, and this is the 7th lecture which is related to the BAB study and study centers and its legal provisions. After completion of this lecture, the learners will come to know what is BAB and other terminology used in the BAB study. Then what is the purpose of BAB study for conducting it? What are the regulatory requirement? Which are the forms and fees, that is CDSCO procedure to apply for the BAB study and study center. Then the learners will come to know what is the chapter 5 given in the New Drug and Clinical Trial, what is the chapter 7 and the guidelines to be used for the BAB study and BAB study centers. So friends, first of all we will see what are the definitions given in the New Drug and Clinical Trial. As you know that previously there were no definition in the Schedule Wise and in the Drug and Cosmetic Rule 9045. With the amendment of the Drug and Cosmetic Rule 9045, that is for the New Drug and Clinical Trials, many of the definition has been given in the rule. So we will see these definitions given in the rule one by one. Let us see first what is means by bioavailability study. So the definition of bioavailability study is given in the rule 2E, and the bioavailability study means a study to assess the rate and extent to which the drug is absorbed from a pharmaceutical formulation and becomes available in the systemic circulation, or availability of the drug at the site of action. The next definition is related to the bioequivalence study. The definition of this bioequivalence study has been given in rule 2F, and it means a study to establish the absence of statistically significant differences in the rate and extent of absorption, that is a bioavailability we have seen, of an active ingredient from a pharmaceutical formulation in comparison to the reference formulation having the same active ingredient when administered in the same molar dose under similar conditions. It means that the bioavailability of the two different dosage form having the same active ingredient should be bioavailable, or the bioavailability should be same. Then we can say the bioequivalence has been achieved for the two different dosage form with the same active ingredient. Coming to the next definition, that is efficacy. We have seen we are always using the words efficacy, effectiveness, investigational product. So the different books, different guidelines have given the different definition. That's why to bring it into the regulation, this definition has been defined in the New Drug and Clinical Trial Rule 2019. So let us see what is means by efficacy, what is means by effectiveness. The definition of efficacy has been given in the Rule 2M of New Drug and Clinical Trial Rule. It is in relation to a drug, means its ability to achieve the desired effect in controlled clinical setting. So the ability of the drug to achieve the desired effect is the efficacy. The next is effectiveness. Effectiveness, the definition has been given in Rule 2N, and it is in relation to a drug, means its ability to achieve the desired effect in a real world clinical situation after approval of the drug. So you have seen that there is a difference, little bit difference between efficacy and effectiveness. In case of the efficacy, it is given in a controlled clinical situation, means in clinical trial or the BAB study, and effectiveness it is given in the real world, means after the approval of the drug and once the drug is in the market. Coming to the next definition, it is a IP, usually we called it is an investigational product. The definition of which is given in the Rule 2S. Investigational product means the pharmaceutical formulation of an active ingredient or placebo being tested or used in the clinical trial. Means whatever the drug we are using in clinical trial or in the BA/B study, including the placebo. So these are called as the investigational product. Now what is means by investigator, principal investigator? So the definition of investigator is given in Rule 2T, and it means a person who is responsible for conducting clinical trial at the clinical trial site. We know that the investigator and principal investigators are there, and the investigator, who is the person which is actually responsible for the conducting of the clinical trial at the trial site, and he is also responsible for the taking care of the patient. The next is of placebo. It is given in Rule 2BB. Placebo means an inactive substance visually identical in appearance to a drug being tested in a clinical trial. It means it is not having any pharmacological activity, it is an inactive substance, but it is identical in appearance, so that if there is a study which is a blinded study, the patients or investigator, they should not be able to identify which is the drug or which is the placebo. That's why it is identical in appearance to the drug. Rule 2HH is for the definition of sponsor. Sponsor includes a person or a company or an institution or any organization responsible for initiation and management of a clinical trial. So any organization, institution who is willing to conduct or sponsor the clinical trial is called the sponsor. The next is a trial subject given in the Rule 2JJ of New Drug and Clinical Trial. It means a person who is either a patient or a healthy person. So here both has been given, patient and a healthy person, because we have seen in phase 3, and when there is a drug of special criteria, that is carcinogenic drug or having the carcinogenicity, in that case we uses the patient also, to whom investigational product, it means the drug which is under trial, is administered for the purpose of a clinical trial. It means the subject or patient, those who are enrolled for this purpose, are called the trial subject. Study center, it is a center created to establish or undertake BA/B study after drug for either clinical part or for both, that is clinical and analytical part of such study is called study center. Now let us move towards the purpose of the BA/B study. What is the purpose of bioavailability and bioequivalence study and why we conduct it? Bioavailability and bioequivalence study is conducted to ensure the release of the active drug from the formulation to the site of the absorption, because the different formulation makings manufacturer, they are using the different excipients, and therefore it is necessary to ensure the release of the active drug from the formulation to the site of absorption, because once it is the drug at the site of absorption, then only it will get absorbed and it will be available in the blood circulation, and once it is available in the blood circulation, then only it can elicit its desired effect. That's why the bioavailability and bioequivalence study is required. This study which would further ensure the excipient used are appropriate and adequate in quantity and added by adopting suitable technology. So the concentration of the excipient used, such as binder, ligand, and these diluent, so they should allow the drug to release in a proper time and at a proper concentration to the site of absorption. And the technologies such as granulation, binding, tableting, these technologies used, that should be capable of allowing this release of the active ingredient. Further, BA/B studies are used to check the pharmacokinetics in the subject, that is absorption, distribution, metabolism and elimination of the drug. Many of the times the in vitro in vivo correlation cannot be ensured with the dissolution study. As we know that dissolution study is also used to ensure the release of the drug, but that is an in vitro study, and many of the time the in vitro correlation cannot be established directly in vivo, and that is not appropriate. That is why we require the study in the subjects. Let us move to the new drug and clinical trial rule, in which chapter it has been given. So this is a new drug and clinical trial rule 2019 in chapter 5. Actually this chapter 5 is divided in two parts. The part A is related to the clinical trial and part B is related to the bioavailability and bioequivalence study. Chapter 7 is dealing with the BAB study centers. Now we will see whether the permission is required to conduct such a BAB study or not, and if the permission is required, whether the protocol which is designed for this study required to get approval before initiation or not, or what is the role of ethics committee in BAB study. So we will see it in our next slides, which is related to the permission protocol approval. So as per the rule 31, no BAB study of new drug or investigational new drug shall be conducted in human subject by any person or institution or any organization except in accordance with the provision of the Act means the Drug and Cosmetic Act, and these rules, that is the new drug and cosmetic rules, and without permission granted by the central means the Central Licensing Authority. So we will see now whether the permission is required to conduct the bioavailability bioequivalence study, whether the protocol which is designed for this study require approval or not, what is the role of the ethics committee, whether the ethics committee is responsible for giving the approval or not, that we will see. So as per the rule 37 of new drug and clinical trial, no BAB study of any new drug or investigational new drug shall be conducted in human subject by any person, institution or organization except in accordance with the provision of the Act and these rules. Act means the Drug and Cosmetic Act, rule means rules there under 1945 and also the rules new drug and clinical trial 2019, and without permission granted by the Central Licensing Authority. The Central Licensing Authority, we know that it is a CDSU, Central Drug Standard Control Organization. So as per this rule, no one should conduct the bioavailability and bioequivalence of the new drug. Here it is important to see, it is mentioned that new drug or the investigational new drug. So whenever there is an investigational new drug and the new drug, the permission to conduct the bioavailability and bioequivalence study is required from the Central Licensing Authority. Every person associated with the conduct of BAB study of new drug or investigational new drug shall follow the general principle and practices as specified in the first schedule. So in the first schedule of this new drug and clinical trial rule, the general principle has been given, and every person or organization, those who are willing to conduct this study, they have to follow these general principles. Let us see what is the oversight of BAB study, who has to monitor and who has to audit these sites. The work of every BAB study shall be overseen by the ethics committee. We have seen what is ethics committee, and those ethics committee which are registered under rule 8 means those which are registered with the CDSU, those ethics committee can only oversee the work. So when to be overseen, that before initiation and throughout the duration of the conduct of such study. Let us see what is the application forms and the procedure. So the application forms and the procedure given in rule 33, which is related to the application for permission to conduct bioavailability and bioequivalence study. The applicant has to apply in form CT05 to the Central Licensing Authority, that is to the Central Drug Standard Control Organization. The fees we have seen in our earlier lecture, that fees are given in the 6th schedule of this DCT. So appropriate fees has to be paid through the Bharat Kosh or through the Bank of Baroda, and the receipt of that challan has to be uploaded. The information and document as specified in the table 2 of the 4th schedule. So these are three basic requirements: the CT form 05, the fees as per 6th schedule, and the document as mentioned in the table 2. We will see that in the later slides what are the documents required. So there is one provision that provided that no fee shall be payable for conducting a BAB study of an institution or organization owned or funded wholly or partly by the central government or state government. So central government or state government agencies, those which are willing to conduct this study, for them there is a no fee. Now let us move towards the grant of permission, and which are the form in which the applicant will obtain the permission to conduct the BAB study. So it is as per the rule 34, the central licensing authority, once it has received the application, it will scrutinize the information and document furnished with the application, as I have mentioned in form CT05, and if there is query and such further inquiry, if any, as may be considered necessary, or if it is satisfied that the requirement of these rules have been complied with, grant permission to conduct bioavailability bioequivalence study for new drug or the investigational new drug in form CT7. So the CT form, the application and the permission in these forms. In case if the licensing authority is not satisfied, he can reject the application, but in that rejection, the reason which they have given for the rejection, that has to be conveyed to the applicant in writing, and this application for the approval or for the rejection, that has to be conveyed to the applicant within a 90 working days from the date of receipt of the application in form CT5. In case where the central licensing authority consider that there are some deficiencies or the document that have not been completely submitted to the central licensing authority, the licensing authority can give the opportunity to rectify the same, and the said authority shall inform the applicant the deficiencies within a stipulated period referred to clause 1, that is a 90 working days. So there should be a communication from the central licensing authority within 90 working days, and if satisfied after submission of the document, the central licensing authority may accept the application, or if not satisfied, then they can reject the application. So once this permission is granted, the permission is given by stipulating certain conditions to be followed by the applicant, and these conditions have been mentioned in the rule 35 of the New Drug and Clinical Trial, rule 2019. Let us see which are these conditions. In these conditions, the BAB studies shall be initiated after approval of BAB study protocol by ethics committee. We know that registration is required for ethics committee. So after registration of ethics committee, the applicant shall initiate the approval of BAB study only after the approval from the ethics committee. In case of an ethics committee of BAB study center reject the approval of the protocol, the details of the same should be submitted to the CLA. Sometimes the applicant takes the ethics committee approval after the getting approval from the central licensing authority. In many of the cases, they first take the approval from the ethics committee and submit to the central licensing authority. Then central licensing authority approves that protocol if all the conditions have been satisfied. In case where there is no ethics committee approval has been submitted to the licensing authority with the condition that they have to take necessary approval, can grant the permission. So in such cases, when after receiving this permission and as soon as they take the approval from the ethics committee, that is required to be submitted to the Central Licensing Authority. Then BAB study of new drug or this IND shall be conducted only in BAB study center registered with the Central Licensing Authority under Rule 47. So, we will see what is the procedure for the BAB study center in our next slides. So, this BAB study protocol once approved, that should be conducted in the center where that center has been registered. The BAB study of this IND shall be registered with the CTRI maintained by the ICMR. So, here it is mentioned study of investigational new drug. So, whenever there is an investigational new drug, that study should be registered with the Clinical Trial Registry of India, the register which is online and maintained by the ICMR. In case of injury or serious adverse event or any termination of any study, that should be communicated to the Central Licensing Authority. The study shall be initiated by enrolling the first subject within period of 1 year. So, earlier these conditions was not there. Now, with the giving the validity period, it has been stipulated that the study has to start within a period of 1 year from the date of grant of permission, failing which prior permission from Central Licensing shall be required. Let us see what is the validity period and its inspection. So, the validity period of the permission granted is 1 year. This is the validity period for the BAB study approval. So, once the BAB study approval has been granted, it would be valid for 1 year, and in case if it has not been started within 1 year, it has to be informed to the Central Licensing Authority. The inspection of premises relating to the BAB study. The person or the institution or any organization permitted to conduct such type of study under Rule 34 we have seen. In CT 7, including his representative and investigator, they shall allow any officer authorized by the Central Licensing Authority, who may, if considered necessary, be accompanied by officer authorized by the State Licensing Authority. So, Central Licensing Authority along with the State Licensing Authority, they can come for the audit of the BAB study center. So, in this case, those who have obtained the permission, they should allow this inspector to, they can come with a notice, prior notice or without notice. In both of the case, they should be allowed, and they can seize any record or statistical result document of related to the investigational drug and any other related material, and reply to the queries raised by the inspecting authority in relation to conduct of such BAB study. So, after the inspection and audit, there may be a suspension or cancellation of the study or the registration of the study center. So, the suspension and cancellation related, it is given under the Rule 38. As we have seen, after permission, there may be a inspection or audit. So, Central Licensing Authority may, after giving an opportunity to show cause, if the auditor, those who have found there is a violation of the condition of the permission, or there is a violation of the protocol which is approved by the Central Licensing Authority or Ethics Committee, and if it is communicated to the Central Licensing Authority, then Central Licensing Authority may, after giving opportunity to show cause that why these deficiencies are there, and after affording an opportunity of being heard by an order in writing, take one or more of these following actions. So, the Central Licensing Authority, after receiving such audit report, or once it knows that there is some violation, so they can issue the show cause notice to the applicant, and once the reply has been received, if it is not satisfactory, then the Central Licensing Authority can issue a warning in writing, but therein they have to describe the deficiency or defect observed during the inspection or otherwise, which may affect adversely the right or well-being of subject enrolled in the study or the validity of BAB study conducted. The Central Licensing Authority can reject the result of the BAB study as the case may be if the results have not been found satisfactory, or if it is found that there is a violation or there is no data integrity, then the result of that study can also be rejected. The Central Licensing Authority can suspend such a study or study center for such a period as considered appropriate or cancel the permission granted. Study center can also be suspended or the permission can also be suspended. They can debar the investigator or the sponsor, including his representative, to conduct any BAB study in future. So once it has been found that there is a gross violation, they can also debar the investigator for conducting further studies. So this is all about the BAB study approval and the protocol. Now we will switch to the BAB study center. Let us see what is the BAB center as per the rule. So as per the New Drug and Clinical Trial Rule 2019, BAB study center means a center created or established to undertake BAB study, bioavailability bioequivalence study of a drug for either clinical part or for both clinical and analytical part of such study. So whether it is a part of clinical trial BAB study with the subject, or whether it is a analytical part of such study, both are covered under the BAB study centers. Let us see in brief what is the process of approving the BAB study center. So once there is a application with the Central Licensing Authority, the applicant has to apply in CTA. Once there is application for registration of the BAB study center, the Central Licensing Authority may inspect that registration center, BAB study center, and grant of registration to BAB study center in form CT9. So once there is application, then there is an inspection, and if found satisfactory in all respect, then the licensing authority can grant in CT9. The validity period and renewal of registration of BAB center is 5 years from the date of its issue. Once it is approved, it is valid till 5 years. And if the licensing authority found there is a violation not complying with the conditions stipulated, they can suspend or cancel the registration. Let us see this one by one in more detail. So the registration of BAB study center, why it is required? Because it is given under Rule 44 of the New Drug and Clinical Trial that no BAB study center shall conduct any bioavailability or bioequivalence study of new drug unless they are having permission from the Central Licensing Authority. So as it is stipulated it into the rule, the BAB study center, those who are approved, they can only conduct the study. The application for registration of BAB study center, the applicant has to be apply in CT8, and the application for registration of BAB study center with the CLA shall be made to the said authority in form CT8 as we have seen. The application under sub rule 1 shall be accompanied by fees all they are given in the 6th schedule, and the other information we will see in our next slide, which are the document required as per the 4th schedule. Then after the application, the inspection can happen on receipt of an application under Rule 45. Any officer authorized by Central Licensing Authority that may be accompanied with the state licensing authorities, and they may cause an inspection of such a study center to verify the facility of the center and the capacity of the applicant to comply with the requirement, whether they are having all the equipments required for the BAB study center, whether there is enough space to conduct such a study or not, whether the competent people are available or not, that can be inspected. After the inspection and after the scrutiny of the information and document furnished by the applicant in form CT8, and after having such inspection and further inquiry, if the licensing authority satisfied that the study center is as per the rules and regulation, then they can grant the registration. If not satisfied, they can reject the application. The reason they have to be recorded in writing to the applicant. In case where the central licensing authority consider that there are some deficiency, they can communicate these deficiencies to the applicant, and after satisfied reply again they can issue the registration, and if not satisfied, then they can reject this. So after the rejection, if the applicant is not satisfied with the order passed by the government, that applicant who is aggrieved by the decision of the central licensing authority, he may file an appeal within 45 days from the date of receipt of such rejection before a central government, and that government may, after such inquiry, once he has filed the application for the grievance, the government may, after such inquiry and after giving opportunity of being heard to the appellant, dispose of the appeal within a period of 60 days. So once the grievance has been filed within 45 days of the receipt of such a rejection, within 60 days the government, after giving a opportunity to be being heard and if found satisfied, may grant the permission, or if it is not satisfied, can continue the rejection. Now let us see what is the validity period and the renewal of registration. The registration granted under Rule 47 in Form CT9 shall remain valid for a period of 5 years from the date of its issue, unless suspended, cancelled by the central licensing authority. Once it is granted, it would be valid for a period of 5 years, unless if there is a violation of the rules stipulated, and if there is a inspection and during that inspection it is found it is not consistently compliant with the rules and regulation, then it can be suspended or cancelled. The BAB center shall make an application for renewal of registration in Form CT08. So for the renewal, again it has to be applied in CT08 along with the document as specified in the 4th schedule at least 90 days prior to date of expiry of its registration. So once it is granted, we have seen it is valid for period of 5 years. So before the expiry of this registration certificate, before 90 days the applicant has to be apply for the renewal of this registration, provided that if the application for renewal of registration is received by the licensing authority 90 days prior to date of expiry, the registration shall continue to be in force until order are passed by the said authority. Once he has applied before 90 working days, and if there is no communication or if there is a delay from the licensing authority, then in that case the license which is already with the applicant, that is considered deemed to be valid till the order are passed by the said authority on the application. The central licensing authority, after scrutiny of information enclosed with the application and after taking into account inspection report and the information required, if he has found that the requirement have been complied with the grant of registration, then he can renew registration in Form CT9. So we have seen the BAB study approval and its condition of the permission. Same here is also there are some stipulated conditions with the registration certificate. The center, these conditions are: the center shall maintain the facilities and adequately qualified and trained personnel as specified in the 4th schedule for performing its function. The staff should be qualified, the facility should be adequate to perform such study. The center shall initiate any BAB study of new drug or IND in human subject after approval of the protocol and other related by document by ethics committee for clinical trial and permission of such study granted by the central licensing study. So this has been checked, but again it has been stipulated that the BAB study center, that is the firm, should not start any BAB studies BAB study prior to approval of the Central Licensing Authority or the Ethics Committee. Where this center does not have its ethics committee, that site may be initiated after obtaining approval of the protocol from ethics committee for clinical trial register under Rule 8, provided that the approving ethics committee accept the responsibility for the study at the center and both the approving ethics committee and center are located within same city or within radius of 50 km of the center. So the ethics committee which is looking after these centers and the BAB protocol, this should be within the radius of 50 kilometers. The CLA shall be informed about the approval of the ethics committee for clinical trial. If the ethics committee approval has been taken after the approval has been granted by the Central Licensing Authority, that should be communicated to the Central Licensing Authority. Then next is BAB study of IND shall be registered with the CTRI, as we have mentioned that if the study with the IND, it has to be registered with the CTRI before enrolling the first subject. Study shall be conducted in accordance with the approved protocol. Whatever the protocol which is approved by the Central Licensing Authority and Ethics Committee, the study should be conducted as per the approved protocol, and this study also should be conducted as per the good clinical practices guideline which is mentioned in the Act and Rule. In case of termination of any such a study, if the study has not been conducted fully or if it has been terminated prematurely, then the detailed reason for such termination shall be communicated to the Central Licensing Authority immediately. The next condition is that if there is any SAE or injury during the study to the subject, such study shall, after due analysis, the investigator has to cause the analysis of that SAE, why it has happened, whether it is related or whether it is not related to the study product. After due analysis, it should be forwarded to the Central Licensing Authority within 40 days of its occurrence in the format as specified in the table 5. So there is a format given in the table 5 in which the principal investigator they have to inform to the Central Licensing Authority in this format. In case of injury to the study subject during study, the complete medical management and compensation in case of study related injury shall be provided. So there is a condition that in case of the injury or SAE, the complete medical management and the compensation to the subject has required to be given, and the time period is given that within 30 days of the receipt of the order. Once the order has been passed by the licensing authority, that has to be given within 30 working days. In case of death, permanent disability, injury or other than death and permanent disability, as the case may be, of a study subject, compensation shall be provided in accordance with the provision of chapter 6 and details of compensation paid to the trial subject or his legal heir, whatever the case may be, in such cases shall be intimated to the Central Licensing Authority within 30 days. So whatever the compensation has paid, that has to be intimated to the Central Licensing Authority. Further, if there is any change in a constitution or ownership of this study center, see, once there is an inspection, then based on that inspection the Central Licensing Authority approves the registration. But if there is any change in the constitution of the director bodies or change in the constitution of the ownership, or there is a major change in the equipment facility, then that should be communicated or that should be intimated to the Central Licensing Authority within 30 days of such a change. The study center shall maintain all the data, records and other documents related to the conduct of the BAB study. The BAB study center shall allow officer of the CDSU, that is Central Licensing Authority, he may be accompanied with the State Licensing Authority, and they can come with or without the permission to inspect any record, statistical observation or result or of any document related to such a study and furnish information to the queries raised by such authorized person in relation to the conduct of the said study. The next condition is that the Central Licensing Authority may, if considered necessary, impose additional conditions in writing with justification. If there are some additional condition related to the what should be the population for the study, then what should be the subject eligibility, that is inclusion criteria, exclusion criteria, or how it should be the assessed, or if it may be related with the conduct and treatment of such specific study, that condition also can be imposed by the Central Licensing Authority. So the BAB Study Center registered by the CLA, including his representative, shall allow an officer, this we have seen. So in case of there is any violation, and after audit, if the applicant or the study center who has obtained the BAB study approval or the study registration, if found that they are not complying with the conditions of the study center and stipulated condition, the Central Licensing Authority may, after giving an opportunity to show cause and after affording an opportunity of being heard by order in writing, take one or more the actions, and these actions may include the issue of warning letter in writing to the investigator to the BAB study center. The licensing authority may reject the result of the study if it is not if it is found that it is not in compliance with the conditions or as per the protocol. They can suspend the conduct of this study in between also. They can suspend for such a period as considered appropriate. So it is the discretionary power of the licensing authority, depending upon the seriousness and the criticality of the observation, they can take a decision. They can debar the center, including its representative, to conduct any BAB study in the future. So this is all about the application, permission, inspection, cancellation, suspension and appeal of the BAB study protocol and the BAB study center. Let us see where is the regulatory mandate of this BAB study and BAB study center, exact position in the rules. So as we have seen that it is mandatory as per the new drug clinical trial rule 2019 in rule 44. The chapter 5 is related to the BAB study of new drug, particularly the part B. Further, there is one notification has been published by the Government of India, that is a GSR 327. By this application, it is mandatory that the applicant shall submit the result of BAB study along with application for grant of license of oral dosage form of drugs specified under category 2 and category 4 of the biopharmaceutical classification system. So as per the biopharmaceutical BCS classification we usually call. So as per this BCS classification, if the drug falls under the category 2 and category 4, for such type of drug, the applicant required to submit the BAB study data. Let us see what is this class 2 and class 4. So according to the BCS classification, that is the biopharmaceutical classification system, there are 4 classes given. The class first is for the drug which are highly permeable and highly soluble. So we have seen in such cases there is no need of the BAB studies. Class 2 is high permeability but low solubility. So those drugs which are having low solubility, there is a problem with the absorption, and for such type of drug it requires the BAB study. Class 3 is low permeability and high solubility. In this case also it is not required as per the notification. Class 4 is low permeability and low solubility. So if there is a low permeability, low solubility, in this case also it is required to have the BAB study of that drug. The last part of our this presentation, that is document required for approval of BAB study center. So in our earlier slide I have mentioned the document as per the fourth schedule table 1. In many of the slides I have mentioned. Let us see which are these documents required for the BAB Study Center approval. First is the covering letter, which should mention where is the BAB Study Center and which approval they require. Then name and address of the organization to be registered along with its detail like telephone number, fax number, email address, that has to be provided. Name and addresses of all the members responsible for this registration, that is proprietor, partner, directors, so their details. Then the organogram of organization including brief CV of key personnel, that has to be submitted. Status of organization as legal identity, whether that has been registered or not, that legal identity, copy of that certificate like a registration certificate, memorandum and article association, that is also required to be submitted. Then brief profile of specific activities, services undertaken by the organization, including facility, resources and infrastructure, these have to be submitted. Then as I have mentioned, the list of equipment in the firm, which are the equipment, whether LCMS, UV, these are available or not, which are required for the conduct of BAB study, that list of equipment has to be given. Then list of the staff in the firm. Next is the list of SOPs and SOP for informed consent process and informed consent form. So we have seen that in the clinical trial in BAB study, the informed consent form is very much having the important. So the applicant or those who have approved a center, they require to maintain the SOP, how to conduct the process of the informed consent, and the list of SOPs also have to be submitted. Then layout of the facility, the design of the facility and its structure, all details related to the ethics committee, including composition of ethics committee. So the first of all, this ethics committee should be registered, the registration number, and further the certificate obtained from the licensing authority by the ethics committee, including its composition, that has to be submitted. All major tie-up for ancillary services, those the agreement made with the hospitals and ambulance in case of the emergency, that is required to be submitted. So this is all about the documentation, and this is the last slide. So let us see what we have seen in our this lecture. So in this lecture 7, we have seen what is bioavailability, what is bioequivalence, its legal definition as per the rule. Then we have seen many more other definitions like efficacy, effectiveness, what is PI, what is the IP. Then we have seen the registration of BAB center, its application, permission, condition of permission, the inspection procedure, and in case violation, the suspension, rejection, what actions can be taken by the licensing authority. Then further we have seen its renewal, validity period, and the documents which are required to be submitted for the grant of registration of BAB study centers. So I hope you have enjoyed these lectures, and now it's your time to check whether you have understood at least to the little extent this chapter, this lecture or not. So let us have check for your memory by asking you some question. The first question for you is that, it's very simple. Which chapter of New Drug and Clinical Trial Rule 2019 mentions the requirement for registration of BAB study center? So in which chapter it has been given? Yeah, it is chapter 7, wherein the requirement has been given. The next question, the report of SAE after due analysis in how many days shall be forwarded to the central licensing authority? We have seen this in our condition of permission. So this is a 14 days. So within 14 days all the SAE after due analysis, not immediately, has to be submitted. The next question is which classes of BCS classification require BAB study? So we have seen, as per new notification, there are 4 classes. So you have to tell which classes require the BAB study. So this is a class 2 and class 4. Well, I think you have understood the lecture. Further, we are having one more lecture with related to the BAB study guidelines. So the things will be better after that lecture also. So we'll see in our next lecture. Till then, you take care. Bye bye and thank you.